Divorce mediation wastes time, money, and effort. There is an obvious better way. Let me clarify something carefully at the beginning here. I'm not saying settlement discussions are useless. I am not saying compromise is bad. I'm not even saying that mediation is always bad. Many divorce and child custody disputes should settle, but I think the role of mediators themselves is often dramatically overstated. Most cases do not settle because the mediator possesses some unique conflict resolution superpower. Cases usually settle because litigation pressure changes the parties' incentives. Attorneys' fees accumulate, discovery exposes weaknesses, trial risk becomes real, fatigue sets in. Eventually, settlement becomes preferable to continued war. The mediator is often incidental to that process. In Utah, mediators cannot make findings of fact. They cannot compel disclosures. They cannot punish dishonesty. They cannot issue rulings or force reasonable behavior. At most, many mediators manage emotional traffic and shuttle proposals between rooms, whether they are virtual or physical. Occasionally, they reality check someone. Sometimes that helps, sometimes it does not. Yet parties routinely spend thousands of dollars on what is essentially supervised indirect communication through the mediator, and shuttle mediation is often especially inefficient. The parties sit in separate rooms, virtual or otherwise, while the mediator walks back and forth relaying summaries, grievances, and settlement offers. Tone gets lost, nuance gets lost, misunderstandings increase. What could have been a direct 4-hour conversation or less sometimes turns into an exhausting all-day game of telephone. Now, there are absolutely situations where shuttle mediation makes sense, going back and forth between the parties without them all meeting together, such as serious domestic violence concerns, severe intimidation dynamics, situations where direct communication would immediately explode. Those cases exist, but they are the exceptions, not the rule. The larger problem is that mediation culture has become ritualized now. Courts order mediation because that's what courts do. Lawyers schedule mediation because that's what lawyers do. Then when litigation pressure finally pushes the parties toward compromise, everyone congratulates the mediator as though the mediator personally caused the settlement. I think that often confuses correlation with causation. Processes that actually change incentives tend to produce more meaningful movement. Arbitration, for example, evidentiary hearings, summary adjudication, Rule 68 pressure, looming trial risk. Those processes force parties to confront reality, and that is one reason I believe arbitration-mediation, or Arb-Med, is often a better model. Under Arb-Med, the arbitration happens first. Evidence is presented. Credibility gets tested. The arbitrator prepares a binding decision before mediation even begins. Then the parties negotiate, knowing adjudicated reality already exists. Traditional mediation is negotiation anchored by uncertainty. Arb-Med is negotiation anchored by impending reality. And in my experience, reality, not mediation theater, is what usually settles cases.